Let's see what it feels like to be part of the class.
It really does.
All right, welcome back to Legal Practice. Today is Thursday, so we're excited about headed into the weekend. And today we're going to talk about presenting oral argument. We're going to talk about what are the goals of oral argument, and then we're going to talk about kind of the nuts and bolts of how we go about doing these presentations. Everybody here, maybe everybody, has at least heard an oral argument before or has some sense of what an oral argument might look like in appellate advocacy. Some people, of course, did Board of Barristers, good court. Maybe you've listened to a Supreme Court argument in a recent case that was interesting to you. Yeah.
When you showed us the video of you talking, was that an oral argument? Or was that, I can't.
Well, which one? Which would remind
You
me?
showed us a video of you. There's an audio clip of you at the Fifth Circuit.
Okay, yeah. So that was an appellate oral argument. Okay. So in this class, we listened to me present one, and you also probably recall from that it's a little bit different than a mock trial or trial opening statement or closing statement, because the judges actually interact with you in an appellate oral argument. You have a presentation that you're giving. You are, talking about why you should win, and then the judges or justices can interrupt you and ask questions that are often adversarial in nature. And that's the thing that gives people some anxiety about appellate argument, because you might start to feel like it's going to be kind of some sort of a debate or a battle of wits with a judge who's been doing it a long time. And I want to kind of give you a sense of how you could approach the tone in thinking about an appellate oral argument to where it doesn't have to be like that. What I want you to think about in oral argument is you're trying to have a conversation with the judge or justice, right? So when they ask you a question, it's often going to be a question that forces you into the weakest portion of your argument. You're going to want to go up there, and there's certain places in your argument where you feel super confident. And it would feel really good to just be in that space the whole time that you're making your argument, because how could you lose at that point, right? But the questions will move you off of that. In fact, you'll often get to spend very little time in that comfort zone of the strongest parts of your argument. But I want you to think of this as kind of a gift and not a curse. Sometimes you will get a judge who's made up their mind and they're trying to damage your argument in the mind of their peers who are also deciding the case. That does happen. But other times you'll have a judge or justice that totally agrees with you on the strengths of your argument, but might just feel like a little bit stuck on this one part of it. They want to rule for you, but they just can't get past this one little thing. And when they redirect your attention to that one little thing, they're actually giving you a great gift. They're giving you the opportunity. They're telling you where they're stuck, and then they're giving you the opportunity to kind of build that bridge for them, right? And so don't ever kind of find yourself frustrated when the questioning takes you to the weaker part of your argument or the questioning seems adversarial. Sometimes that's in bad faith, but sometimes that's also in good faith. And you want to try to do the best you can to engage all the questions, okay? In terms of tone, of course, we're never going to be combative even with the judges who are trying to harm us or damage our argument. Our tone, you should think of it kind of as the tone of a job interview. Of course, the ideal that people say is you want it to be conversational. But conversational in what sense? You want it to be professional. You want to come across as confident. You want to come across as knowledgeable. You want to be able to engage the judge or justice. But you don't want to be so casual. You don't want to be cracking jokes unless you really have a past relationship with those judges. You've argued in that court a million times. Then maybe there's opportunities to kind of show a little bit more personality. But generally speaking, treat it like the tone of a job interview. You want to come across as professional, you want to come across as knowledgeable, you want to come across as confident. But at the same time, you don't want to go too far in any of those directions, and you want to be conversational. So when you get asked a question, even if it's not a kind question, you want to engage it in good faith and just do your very best to answer the question, and then pivot back into the main argument or presentation. Okay? So that's the mindset you want to be in, kind of going into it. We'll talk about a little bit more in a minute. What you're not going to be doing is just reading something that you've written. You want to be explaining it or kind of teaching the judge or justice about why you should win, right? Because we're always keeping our reader in mind, defined broadly, when we're thinking about the art or craft of persuasion. So let's get a little bit more into the nuts and bolts of it. Amy's going to pass out a handout that's going to tell us, well, how do we go about organizing an appellate argument? How do we structure it? And we're going to kind of start with a little bit of a formula in something that's sometimes called the roadmap. So Amy's going to hand that out. We'll give that just a second. Okay, so everybody has one. This is actually two pages long. There's a front side and there's a back side. So we want to have the side that's not boxed in. That's where we're going to start. So the more spacious side of the piece of paper. And this is kind of a formula for how to begin your appellate oral argument. What I call the roadmap. Some people also use that terminology. So what do we always say at the beginning of ever addressing a court? There's an important thing you say that identifies that the proceeding has begun, your presentation has begun.
Your Honor, or may it please the court?
May it please the court, right? That's always going to be something I say. If it's not the very first thing I say, it's going to be really, really close to the first thing I say. Now, those of you that have participated in Board of Barristers say, well, hold on just a second. You're supposed to say, Madam Chief Justice or Mr. Chief Justice, and may it please the court, right? Because that's what Board of Barristers taught us. And I'll say that that is true if you're arguing at the U.S. Supreme Court. Because you're going to have the chief there presiding over the case. That's also true if you're arguing at a court of appeals and the chief happens to be present. See, at the Fifth Circuit, for example, they've got 16 judges. Every case is randomly assigned to 3 judges. Well, then you also have a bunch of senior judges who've taken senior status. And they also, from time to time, preside on these 3-judge panels. And so you do have a chief judge at the Fifth Circuit. In fact, we have a new chief judge just recently, Chief Judge Jennifer Elrod, who's coming to speak at the law school later this semester, or so I've been told, right? And prior to her, it was Judge Priscilla Richmond, and then it goes back and back and back, okay? So if Judge Elrod happens to be on my 3-judge panel, then I'm going to say, Madam Chief Judge, and may it please the court, because the chief is present. At the Supreme Court, the Chief Justice will always be present because they always, unless he recuses, right? Because they all hear all the cases together. So, yeah.
So at the Court of Appeals, it would be Madam Chief Judge, and at the Supreme Court, it would be Madam or Mr. Chief Justice. The Justice would be, okay.
Yeah. And so if I'm at the U.S. Supreme Court, it's Chief Justice. At the Court of Appeals, it's Chief Judge. At the Texas Court of Criminal Appeals, it's Chief Judge. And at the Texas Supreme Court, it's Chief Justice. What is it at the Amarillo Court of Appeals? It's Justice. So you just have to know they all go by different names in different places, but in the circuit courts, it's Judge, right? So Generally speaking, it would be a low probability event at a court of appeals to where you would say, Madam or Mr. Chief Judge, because oftentimes they're not present on the 3-judge panel. Right? So you usually will begin with, may it please the court. Question?
You're not gonna get like dismissed if you don't address them properly, right?
No, your case will not be dismissed. I've seen some things. And you cannot play games in federal court. You know what I mean?
Yeah.
I would be scared to death of not saying, may it please the court, for example, in an argument at the Fifth Circuit. It may not go well if I don't, right? And there's lots of articles on Above the Law you can read about bad things happen to people who don't do exactly the way they want it to be done. May it please the court. That's a sign of respect, kind of letting them know that your presentation has begun. Right? What do you do after that? I think it's professional. Not everyone does this, to introduce myself, say who I represent, and what role they're playing in the case. Right? And you see right here, it just tracks along this piece of paper. My name is Brandon Beck, and I represent Jerome Garcia, the appellant in this case. Right? I think that's courteous, I think that's polite, and I think it keeps everything super clear. Well, after you've done that introduction, the next thing you want to do is your first opportunity to kind of frame the case or frame the issue in the case. Is to say something about what the case is about or what's at stake in the case. I've labeled these different parts, if you turn the page over to where the boxes are, with different titles. So I call that the about statement, right? Your Honors, this case is about blank. Or at stake in this case is, or at issue in this case is. But it's usually one sentence that kind of describes how I want to think about the case and how I want the court to think about the case. Okay? Then I'm going to have identified a few kind of points that I'm going to make, the different kind of bridges I have to cross to get to the finish line of my argument. And the next is when I articulate that or signpost that prior to beginning my presentation. Right? So you can say, and there are 3 reasons why this court should, and then I'm going to identify the relief I'm seeking. There are 3 reasons why this court should reverse and remand. First, say it. Second, say the second reason. Third, say the third reason. And then say, to my first point, Your Honors. And then I've formally begun my presentation. I'm past my roadmap. Okay. When doing this, think about, well, what are the main points? What are the different bridges I have to cross to get to the finish line? Well, you're going to be doing your oral argument on your appellate brief, right? For those of you that sign up, and we have sign-ups on Twin that are up right now. Well, what would be an example of a first point? What's the first bridge that I have to cross in the appellate brief in order to get to the finish line? Yeah.
Jerry was in custody.
In custody. Right. Well, what's the second bridge I have to kind of cross keeping this idea? Yeah.
Mr. Garcia was being interrogated.
He was being interrogated or subject to interrogation at the time he signed the sworn statement. What would be a third point?
This is analogous.
Yeah. This case is analogous to Mathis versus United States and distinguishable from United States versus Salgado or something like that, right? Now, if you were in Board of Barristers, sometimes they tell you you have to have 3 points in an appellate argument. In moot court rules, you have to have 3 points. Well, that's not true. You have as many points as the case requires. You don't want to have more than 3 points. that would become disorganized, right? You can have fewer than 3 points though, and that's fine, but you want to capture the scope of what you're about to argue because you're framing and setting up the organization of it, and then that's going to kind of carry over into the rest of your presentation. Okay. So this, what I've just described, question?
Yeah, so you've talked a little bit about when you have cases that have a lot of bridges that you have to cross to be able to help your client. How do you break those into 3 points? You just do subpoints under each of them, or something different?
Well, the good news is that a lot of the case is going to be decided on the written briefing. And so we don't have enough time in oral argument to cover all the ground. So I mentioned before, I've briefed a case that's very long that had 9 major points, right? And each one had subpoints. And what do you do when you argue a case like that? You just be really clear about what you're seeking to accomplish. Your Honors, in the written briefing, I identified 9 issues on appeal, but here today, I'm going to focus on 3 of those issues. First, second, third. And while letting the court recognize, I'm happy to answer questions about the other ones. Let's talk about it. But just for this presentation, I'm going to focus on 3 of the issues. Yeah.
How often, when you go to do the oral arguments, are they asking questions about the points that you aren't even like talking about? And then how do you maintain like addressing points that aren't in your presentation at all with still getting what you want to say in the time that like you have?
This is, okay, good question. They can ask about whatever they want, and there's nothing you can do about it. Right?
Love that.
And you have to you're here to help them figure out the case. You're here to help them understand why you should win. I was going to say, what was the second half of it?
And then like, whenever you're spending a bunch of time trying to tell them one of the other points.
Got it. You have to completely give up the idea that you're going to get to everything you want to get to. You're going to talk about what the judges want to talk about, period. If they don't ask any questions, yeah, you're going to go at your own pace and cover the ground you want to cover. As soon as they start asking questions, you're here to help them, period. And that means you had this really great line, this really great thing that was just going to kill, and you're not going to get to that, right? Let me give, I'll remember the hands so you don't have to raise your hands.
Okay.
Really great story recently. There was a recent case that the Supreme Court decided. It was originally called Garland versus Vanderstock. Then it was called Bondi versus Vanderstock. The Supreme Court just decided it about 2 weeks ago, but it dealt with these, what's sometimes called ghost guns or gun kits, right? So you can order...
Ghost gun with no serial number?
Yeah, you can order parts basically that don't have a serial number, and then you can assemble a firearm on your own. And so long as you use the kit and you don't make certain modifications, it can be entirely legal to do that, right? Or maybe not, right? So the ATF had a rule that prohibited certain aspects of this, right? And it went all the way up to the Supreme Court as to whether the ATF's rule regulating this is constitutional or not, okay? Well, the person that argued it on behalf of the government was former Solicitor General Elizabeth Prelogger. Elizabeth Prelogger is the most skilled oral advocate I've ever seen, okay? And I've seen her argue, like, in the courtroom, right? And she's the best, right? This is not a political thing or anything. She's just skilled. And I think she could give the best possible presentation of any argument. Well, so she's defending the regulation, right? And part of her observations are that you don't really have to do a lot. This is really kind of a workaround of the serial number requirement or something like that, right? Well, you find out in response to a question right at the end of her argument that, oh, by the way, this morning before the oral argument, I actually assembled an AK-47. And here are the steps that I took to do it. It took me about 30 minutes to do. Right? Can you imagine having that in your pocket in having the discipline to not just have it be the first thing that you said? Because it just totally killed, right? But there was a really good chance she didn't even get to say that, hey, by the way, I just did one of these. And she had the discipline of just, hey, I'm here to answer your questions. Maybe I get to the fact that I have this huge zinger, waiting. And she happened to get to it, but it would be very difficult to have the discipline, to have something that good in your pocket and just not just be all over the place with it, right? And so how much good stuff else was there that she just didn't get to and was comfortable not getting to? So that is amazing. And so, but you have to be comfortable with the idea you're not going to get to everything you want to. And there's some really good stuff that you wish you could say that you really think is going to stick and you just don't get to it. And the solution is not to start talking faster so you can get to everything, because then you're going to lose the persuasive effect. You want it to be conversational. Okay, back and then here.
I have a question in terms of strategy, kind of like going off of David's question, is like you have 9 points. I know that they're probably going to ask you questions about your weaker points. So is it like one strong point and then like I don't know how you'd strategize, because you don't want to talk about the weak parts, but I'm sure that's what they have questions about. So how do you kind of like maintain control of the fact that like you're not hiding these, but you want to present your strongest case?
You want to talk about the stuff you think the judges are going to decide the case on.
Okay.
Sometimes that's the weakest point you have, because you go in knowing they're going to make me lose on this. So if I can defend this and stop the flood going through, then I still have a chance. So you really have to put yourself in the mind of the judge or the reader or the listener to think, how are they going to decide this case? And a lot of times that's me focusing on the weakest point, because I think that's where they're going to make me lose. And if I can defend that, I can then maybe get to some higher ground in another place. So question up here.
Yeah, so whenever they're asking questions, it's not coming from their copy of the appellate argument, or where is it coming from?
Well,
because I assume they have a copy too.
Oh yeah. So by the time you get to oral argument, the argument has been analyzed 8 million different ways, right? So let's say I write up an appellate brief, I file it at the Fifth Circuit, right? Then the other side, the government, will have 30 days to file a response brief. Then I'll have 15 days to file a reply to the government's response. Then that case will go to an initial panel of judges who will have their clerks, and including them, do kind of a review of it, maybe make a recommendation. And then ultimately that will then go to the final panel of 3 judges who will decide the case. At that point, they'll decide whether to have oral argument. If they decide to have oral argument, each one of their clerks will prepare a bench memo that kind of breaks down the arguments, maybe suggests some questions, things like that. And so by the time you're in oral argument, the idea is at least that everyone is totally clear on what the issues are, what the strengths and weaknesses of them are. And then we're really just kind of working on the details at that point, right? Sometimes it feels like that, sometimes it doesn't, but you're pretty far along into the process. Maybe I filed my brief a year ago, by the way. So I had an oral argument I mentioned before that was recently canceled. It was set for the week of April 28th. Well, the brief for that case I filed last summer.
Oh, I'm thinking this was like immediate.
Yeah.
That makes sense.
And so that's been kind of in the washing machine or whatever, churning for 10 months, 11 months at that point, right? So they take their time and you can't rush them. You cannot rush the Court of Appeals. They're in charge. And so that's something to know. So anyway, so what do you do at this point? You've got through your roadmap. You want to try to have that memorized. And then you get to your first point. Well, each one of your points, I want you to have a separate page that's an outline for that point. We're not going to have it all typed out. We're not going to be reading it. We want an outline. And we want a page for each point. And that way you can stay organized when you're up giving the oral argument. Okay? So let me show you, I keep my outlines for all my cases I argue. So I just want to show you, if it's helpful, kind of what my outlines look like. And sometimes they seem kind of more detailed. Sometimes they're more kind of bare bones. And it all just depends on the case and what I'm trying to accomplish in that case. So let me see here. Okay, so we got some cases here. So if I were to click on this, it's a case I argued many years ago. What do I have here? I've typed out a roadmap that I'm going to have with me that I've had memorized, but I'll take it up there with me kind of as a security blanket or something like that in case I totally space out for some reason, right? And then in addition to that, I'll have one page for each issue. At the top I'll have, and these are my points, the first here being that Amendment 794 is retroactive. That was the first argument I was making. And then I can tell you that just by looking at this outline, I can tell that I was dealing with a variety of factors. This is likely a factors test because I actually have 5 different things listed here, and then I have a little note of how I'm going to argue that particular factor, right? I have a case cited here. I have no idea. I have no memory of that case, but at the time I knew exactly what I had it there for. And then I've got a couple other cases here. At the time I knew exactly what those were there for. I don't remember anymore, right? Then I have something that was the rule, I guess. A clarifying amendment does not change the law. It tells the court what the law was before. I also have a second issue here on something else. And I have some different definitions that I've gotten from the U.S. Sentencing Guidelines in this case. I have, I guess, a case called Cumbie, and then maybe it has some different facts or factors or something like that. But I don't have something typed out that I'm reading. I have something that I'm referring to. So same thing with this next case. I have a roadmap that's typed out. I have an about statement. This case only had 2 points. Excuse me. And then you see at the top, I have the main kind of point that I'm making. So I can always say that brings me to my first point, and then I have it written at the top for me. Or that brings me to my second point, that I have that written at the top for me. That's one that actually does go onto a second page, which is not good. And then just have these notes. And so this is the way I do it. It's been helpful for me. It helps me stay organized, right? So in this case, I had 3 pieces of paper with me up at the podium. I had one that was my roadmap, that as soon as I get through that, I take that and kind of set it down where it's out of the way. So if I had, let me see, I don't have enough pieces of paper here, but if I had 3 pieces of paper here, I'll have my roadmap on top. I'll have that memorized. As soon as I get through my roadmap, I take it and I'll set it down. There's usually a space to do that. And then I've only have 2 pieces of paper in front of me. One is for point 1, one is for point 2. And so I'm never going to get lost. If they ask a question that's on point 2, well, that brings me to my second point. I know to have that in front of me. Or if they want to go back to point 1, I go back to my first point. Because I always start with a new piece of paper for each point, I'm never having to find where my argument starts, that part of it in the middle of a page or anything like that. So even if it was only this long for a point, that would be a separate piece of paper for me because that's my organizational system. Okay. Any questions about that? Yeah.
So like one thing that like Board of Barristers people tell us though is like anticipate what questions they're gonna ask and try to have like responses kind of written or like at least understood that you could say for those questions. Do you tend to do that? Or with some of these you're like, my appellate brief has 9 different points. I have no idea what they could ask, so we'll just know my whole argument decently well and hope I can respond.
Right, well you have to know all the cases you rely on. Those are all fair game. You have to know all the cases the other side relies on. Those are fair game, right? This is just, generally speaking, in any real argument, this is the expectation. You understand your argument, you understand opposing counsel's argument, right? So in that sense, everything's fair game. I think through process of reflection, and through practicing, which is called mooting, you can get to the point, if you're well prepared, where you can predict 90% of questions that are asked. You can predict all high probability questions. And so the problem comes up is when you get that 10% of unpredictable question. Well, then you have to rely on your base knowledge of the argument and the law to be able to work through an answer to that question in real time. And that's the stuff that can kind of keep you up at night. You do want to get to the point where you can hit a home run with any high probability question. And you get there in the preparation process. And so you can do that with writing it out. You can do that with flashcards. You can just do that by thinking about it. I've tried all of these different methods, and they all have certain value. And so you've got to figure out kind of what works best for you. But the practicing or the mooting process and then kind of having a period of reflection after a moot is the best way of doing it, right? So you'll practice an argument, you'll get a question, you can kind of know what you want to do with that question, but it didn't really work. And so you go back and you reflect on it and say, okay, how could I have answered that question differently? And then you kind of refine it, and then when you moot it again, let's say you get that same question again, boom, you hit a home run, but now you get another question that, I'm a little uncomfortable on this. Let's see if we can make that like something we really are happy to hear, that question. So, because we know we're confident in that space too. And it's through that preparation process that you can kind of get to cover all your bases, and you get to learn your argument a lot better that way. So, it's hard and it's fun and it's interesting, but a lot of it is taking some reflective time in between the practices to make improvements. Because if you don't do that, then you're just reinforcing bad answers, right? It's just like writing a draft. If you don't edit it, then it's just might be getting more not good in some way. I don't know. But you always want to take time to look for room for improvement. Does that make sense? Okay, so we've got this roadmap. We've got a sense on how to do the presentation. We know we're going to get questions. I do have an example, and it's something that you can also